Welcome to another Business Insolvency Helpline Guide. Today we look at what is a compulsory liquidation. We aim to cover a number of points in today's guide, including what is a compulsory liquidation, what are the grounds for compulsory liquidation, what's the process, as well as the role of the liquidator. Can you appeal or stop a compulsory liquidation? And impact of compulsory liquidation on directors. What is compulsory liquidation? Compulsory liquidation, or compulsory winding up, is an insolvency procedure in which a company or partnership is forced into liquidation by a court order, also known as a winding up order. Compulsory liquidation is usually initiated by creditors via a winding up petition in the High Court. Less commonly, it can be initiated by directors, shareholders, or an official receiver, who is an officer of the High Court. Administrative receiver, an administrator, a supervisor of a company voluntary arrangement, the Financial Services Authority, the Chief Clerk of the Crown Court, a Clerk of Petty Sessions. Compulsory liquidation is usually the last resort of a frustrated creditor to get paid, either by forcing the directors to act or gaining access to the company's assets. It can also be initiated by HMRC, even when a company has no major assets, simply to set an example to others. What are the grounds for compulsory liquidation? The grounds for compulsory liquidation include when a company cannot pay debts of £750 or more, if the court concludes that it is just and equitable that it be wound up, when the limited company does not commence its business within a year from its incorporation or suspends its business for a whole year, has less than 2 shareholders, unless it's a private company limited by shares or guarantee. The process of compulsory liquidation is set out in the Insolvency Act 1986 and the Insolvency, England and Wales Rules 2016. 1. Statutory demand is issued. Before compulsory liquidation occurs, a statutory demand will be needed if the creditor does not already have a court judgment for the debt. The creditor can issue a winding up petition if the debt is still unpaid after 21 days. 2. Winding up petition is served. The court will then set a date for a hearing to decide whether the petition should be turned into a winding up order. The petition will also be advertised in the London, Belfast, or Edinburgh Gazette. 3. Bank accounts are frozen. The impact on the business can be devastating, as the bank account will be closed immediately without notice. Additionally, because all finance houses have access to this information, securing credit becomes extremely difficult. 4. Winding up order. A winding up petition that has been heard and approved at court becomes a winding up order. At this stage, the company is closed and forced into compulsory liquidation. 5. Official receiver. The official receiver will usually examine the annual accounts of at least the past 3 years, as well as management accounts, invoices and other relevant paperwork, to determine whether the company's demise could be wholly or partly attributed to legal wrongdoing on the part of the company directors. 6. Appointment of liquidator. Where assets are realized, the official receiver's role will be followed by a licensed insolvency practitioner to take over these duties. 7. Statement of affairs. After the appointment, the liquidator will prepare a detailed document listing the company's assets and liabilities. The process of compulsory liquidation can be a complex and time-consuming one, but it is a necessary step in ensuring that the company's creditors are paid and that the company's assets are distributed fairly. The length of the process can vary depending on the size of the company and the complexity of its affairs. The role of the liquidator. The liquidator's role in compulsory liquidation is to obtain the best return possible for creditors while formally closing the limited company. Following the winding up order, the court will appoint an official receiver as provisional liquidator. A privately appointed insolvency practitioner will take over if the creditors wish. They are responsible for finding and selling assets at fair market value and paying creditors. The liquidator's fees will be paid as an expense of the winding up, second only to secured creditors, with a fixed charge in order of priority. The liquidator is also responsible for investigating directors' actions to ensure no misfeasance has occurred, which may have lessened the returns to company creditors. Can you appeal or stop a compulsory liquidation? Compulsory liquidation can be stopped at the winding up petition stage under the following specific circumstances. If the debt is paid in full. If the debt is disputed. If the debtor company agrees to terms with the creditor, who then withdraws the winding up petition. In some cases, the debtor company may assure the court it intends to pay, if sufficient time is allowed, and the court may agree to an adjournment. Very rarely are repeated adjournments sanctioned by the court, and the extension timeframes are generally weeks, not months. If the winding up order itself has been made, it is much more difficult, but it can be done through two methods. Via an application to stay the liquidation proceedings. This can be made by the official receiver, the appointed liquidator, any company shareholder, or a creditor. Any party has the right to apply to have the winding up order rescinded within 7 days. It would need to be demonstrated that the court did not have all the relevant facts when making its decision. What's the impact of compulsory liquidation on directors? Even after the company has been wound up, your duties and responsibilities as a company director do not stop. For example, directors may be required to assist the official receiver in the disposal of assets. If you are a company employee and a director, you will be told how to claim any money owed to you. You should be aware that any insolvency process will involve a directorial investigation, where the insolvency practitioner checks for the possibility of misfeasance. This may mean wrongful or fraudulent trading, but is essentially there to ensure the law was followed. Where misfeasance is discovered, penalties include being held partially or fully liable for the business debt, and in some cases, directors' disqualification. Thank you for watching our guide. Key points to note include: compulsory liquidation is severe and final. You should take professional help immediately. The sooner you act, the more options you'll have available. Your conduct as director will be investigated, and you could face the consequences if it's discovered that you acted improperly. Voluntary liquidation is preferable with more directorial control, if the liquidation cannot be avoided. To speak with one of the team to see how you can avoid compulsory liquidation, simply complete the online inquiry form.